Hi, I'm attorney Francine Ward, and in today's segment, we're going to talk about who owns a copyright. Okay, so the general rule of law is that the person who creates the work of art or authorship is in fact the person who owns it, unless there's a written agreement that states otherwise, or unless the work is a work for hire. So what's a work for hire? Okay, let's say, for example, you're an employer. Anything that well, let's turn it around. Let's say you're an employee, and you're an employee that's creating a work of art, some kind of content, while you're working for your employer. Anything that's created within the scope of your employment is owned by the employer, not by you. Now, this becomes problematic in, let's say, for example, you're an employee and you create this fabulous marketing piece. It's a short video and you're doing it to sell the company. I mean, it's really awesome and you did a really bang up job. But you did it while you were an employee of this company. Okay, so you're leaving the company and you want to be able to show this next company what great work you've created. So you figure, oh, I'm going to take this video, make a copy, and show it to this new potential employer. Well, if you do that, you in fact will be committing copyright infringement because you do not have the right to make a copy and then show it to someone else. Why not? Because you don't own the rights to that video. You created that video while you were employed by this company. So in fact, let me repeat again, that anything created within the scope of one's employment belongs to the employer, not to you as an employee. Another way it shows up as a work for hire is if you are an independent contractor. Now, this area gets to be pretty tricky, and this is where lots of people get very, very upset. You know, when I'm doing programs, and I often do programs for companies and, associations for small business owners, just educating them on what copyright or any kind of IP work is. But this is an area that's always sticky because a work for hire also can be where you as an independent contractor create something, then you own the rights to that work unless you signed away your rights in a written agreement. So let's say, for example, and I bet you, I'm going to throw out this question, how many of you think that if you hire a photographer to take your picture, you own the rights to those photographs? Now, I bet you most of you do not want to put your hand up, but I would imagine most of you believe if you paid money to that photographer, you own the rights to those photographs. Or let's say you hire a graphic designer to design this fabulous logo and these marketing materials for you. I bet you believe that because you paid them, you own the rights to that work. Likewise, how many of you believe that if you hire a web developer to design this awesome website with all the bells and whistles, that because you paid them, you own the rights? Well, you would be wrong if you thought that. Again, the general rule of law is the person who created the work of art or authorship is the owner of the copyright unless there's a written agreement in place or unless it's a work for hire. So here's the deal. If you're someone, for example, who wants to own the rights, let's say you hire a photographer and you want to own the rights to that work, then you need to make sure beforehand that there's an agreement that basically says that it's a work for hire, that they are not owning the work, that you in fact own the work. You own the rights to those photographs. And likewise, with any other content that you hire someone to create for you, you want to make sure there's a solid, enforceable, valid agreement in place that in fact gives you the rights to the work and not the person who's creating it. One other thing, when we talk about ownership of rights, it's always an important topic to bring up, and that's joint ownership. Very often, and I got to tell you, I see this just way, way too often because creative people, what I have found in my experience, creative people just don't think about business. You know, they don't stop to think about contracts and stuff. They don't stop to think about what potentially could be a problem until there's a problem. Because most creative people, they're just so busy thinking, let's create, that's really all that interests their mind until there's a problem. One of the biggest issues I have with clients that come to me these days is to make sure they read those agreements and understand them before they sign them, and also to make sure they in fact have agreements in place before they enter into any kind of business relationship. And one of the clear collaborative relationships that one needs to have some kind of agreement in place regarding is when there's a joint ownership of rights. So here's how it could show up. Let's say you are doing a speaking engagement and you want to work with someone else to do that speaking engagement with you, and you're both creating content. Let's say you both create the handouts and the materials. Let's say you even co-write a manual together that you want to distribute, that you want to sell as a product during this workshop. Well, 9 times out of 10, you didn't think through who owns the rights to that manual, and that might be one of the questions that you ask yourself up front. Who owns the rights, and how will it be divided? Because if you don't, if both of you on some level contributed to that work, an argument could be made that it was a joint work of authorship. And let's say, for example, one of you, the person who initiated the whole deal, didn't intend for it to be a joint work. But because it wasn't clearly stated that it wasn't, again, an argument could be made that in fact it was a joint work. Another way that it could become even more problematic, let's say you've got two people that go in on a project together, but one person comes up with the brilliant idea for this project, and if it wasn't for that person's idea, there in fact would be no project. But the other person actually does all the grunt work. They put it all together. Now, as I've said in another video, copyrights, an idea cannot be protected by copyright. So technically, the person who came up with the idea doesn't have any rights. But the problem could be if they feel that they do. They can, even if you were to go to court and you were to win, if you were the person who did all the work, you would still have to defend yourself in court, stating why the other person doesn't have any rights. Where, had you just had a simple agreement to clarify who owns the rights and who doesn't, or how the rights were to be divided, that would be taken care of in advance. So the thing is, you want to make sure you have some agreement in place. You want to make sure if you have some kind of collaborative relationship with someone else, you want to make sure that it is very clear up front who owns what, and you want to be specific. And if there is an intent that it's going to be a joint work. Okay, that's it for now. I'm attorney Francine Ward, helping you protect what's yours. Bye-bye for now.